Please be seated. We're ready for argument in 23-956, Lane versus the Commission for Lawyer Discipline.
Please the court. Ms. Lane will present argument for the appellant. The appellant has reserved 3 minutes for rebuttal.
Good morning. May it please the court, your honors, justices. Najla Lane, respondent appearing pro se. Thank you. This case raises critical concerns about the application of Rule 1706 of Texas Rules of Disciplinary Procedure, the principles of proportionality, and the jurisdictional limits imposed on disciplinary actions. At its core, this case poses two fundamental questions. One, does the Board of Disciplinary Appeals, BODA, have the authority to discipline an attorney for conduct that occurred outside the 4-year limitation period established by Rule 1706? Two, did the respondent waive the limitations defense by failing to explicitly plead it in her June 28, 2023 response and objection to first amended order to show cause on petition for reciprocal discipline, show cause response? The answer to both questions is clear, no and no. Importantly, Rule 1706 limitation period is jurisdictional, meaning it cannot be waived or forfeited regardless of whether it's affirmatively pleaded. Rule 1706 jurisdictional nature and its principle of fairness and due process allow no room for overreach or procedural misinterpretations.
Isn't the reason that we have limitations so that people don't have to be worried all the time? Oh my goodness, I'm going to be disciplined, a lawsuit's going to be brought against me, etc. But in this situation, that had already happened. There was a disciplinary proceeding, and the repercussions of that and the result of that happened in Illinois. So why would limitations apply in this situation?
If it wouldn't apply, the respondent attorney would not have a finite solution. It would go on and on forever. And
How so? It was ended in the other state. Texas is just recognizing what happened in the other state, assuming it was also a violation here as it was here.
Correct. This violation that's where I was going to get. First time when the first complaint came in 2018, the respondent was already disciplined. And that was carried over to the state, and the state, after a hearing before the hearing board, for the second time, disciplined the attorney. Ms. Lane, attorney respondent, is an American dream. Basically, she was licensed in several states and several federal courts, and she had to endure the consequences of this one conduct. If you would call it a crime, one punishment, it's not concurrent. If it were concurrent, if the respondent is licensed in multiple states, it should apply concurrently at the same time, and it should not go on for years and years and decades. This is almost a decade old. This infringes upon the livelihood of the respondent. There has to be a finite. We have rules. 1706 is a statute that prohibits punishing an attorney outside the 4-year window. So
is there a reason for it going on in that the order, the initial finding of discipline was challenged and went through the appellate process, and certainly that's absolutely the right of any lawyer, but can reciprocal discipline be brought on a finding that is still subject to challenge and on appeal? And so does that make a difference in terms of the concurrentness? Because it would have been concurrent had there been no challenge, but because there was a challenge, it took several years for Illinois to finally conclude that process.
Yep.
So should that make a difference?
I think, as you put it, with the appeal process, respondent is entitled to her right to appeal this matter, because in the heart, respondent believed that this was unjust, unfair, and she was never heard. She did bring it to the attorney registration attention that she felt that this punishment was severe because she was already punished in the federal court, and if it had been non-protunct, concurrent, there wouldn't have been an issue. But every state had their own procedure, and it dragged out. For example, COVID happened. Years the courts were closed. That's to no fault of the respondent. And when the courts opened again, and she had the right to appeal to be heard before the Illinois Supreme Court, she was not heard. Her petition was denied, and they affirmed the lower court. At that point, it should have stayed. If we forget the federal court suspension, that was in 2018. Now we are in January, effective February 7, 2023, respondent's supposed to be suspended another 6 months. If that would have been concurrent, because the respondent was licensed in Michigan, in Texas, and in Illinois, it would have all stopped. But the start and end, it goes on for years. This costs time, emotions, and expenses to fight this all along. We have the rules for a reason. And as I stated in my brief too, that if the rule like 1706 has specific exception, but the exception does not include the reciprocal discipline, then it has to adhere to the same rules. So the attorneys going forward in the future, all Texas attorneys have a finite that they know the rules do apply. I cited the city of Houston versus Williamson, that's Texas case from 2011, where the rule contains an express exception for compulsory discipline, but purposely omits any similar exception for reciprocal discipline. The doctrine of inclusio unius as exclusio alterius is the presumption that purposeful inclusion of specific term in a writing implies the purposeful exclusion of terms that do not appear. In this rule, we have the clear language and the intent of the rule.
But I think the commission's argument is that the rule doesn't apply in the first place because of the way that professional misconduct is defined. So the rule says you can't be disciplined for professional misconduct that occurred more than 4 years beforehand, but the relevant definition of professional misconduct that they're relying on says conduct that occurs in another jurisdiction and results in the disciplining of an attorney in that other jurisdiction. So their argument is that because of the and in there, that until the disciplining in the other jurisdiction occurs, the 4 years doesn't start to run. So what's your response to that?
My response is first, which order are we speaking about? Because there was January 22nd, 2018, from Northern District of Illinois, an order imposed for 6 months suspension.
Well, I think they're not relying on the Northern District order. I think they're relying on the Illinois State order, if I'm not mistaken.
Well, my case, this case is really a case between the cracks, because initially in 2020 even, when respondent was imposed a federal suspension, and she did report this conduct, even though she didn't have to report it under Rule 8.03F, it was not required from the respondent to self-report discipline from federal, but then the rules changed. After 2020 and 2021, they added into the language that federal suspension also to be reported. But either way you look at the definitions, because I understand that the commission argues that the 1706 does not apply to reciprocal discipline because, as you stated, the case arises from final judgment in another jurisdiction, not from grievance. This argument is legally flawed because if that was the case, when you look at the definitions are crystal clear. It says complaint. What does complaint mean? It means the grievance that received by the Office of Chief Disciplinary Counsel, which responded in 2020 reported this, and again in 2023.
I think that's a slightly different point, because the limitations period, it has to be professional misconduct, and there also has to be a grievance. And I understand your point about the grievance, but that doesn't change the way that professional misconduct is defined.
Not according to the definition, Your Honor, because the definition states a complaint alleges professional misconduct, and the facts alleged in a grievance, and then you go, what is a grievance? It means a written statement from whatever source. So Illinois suspension order is a grievance in the language of the definition from whatever source, and apparently intended to allege professional misconduct by a lawyer received by the Office of Chief Disciplinary Counsel. Now, what is professional misconduct? An attorney is an attorney, and if the attorney had a misconduct, that is defined, the acts and omission of an attorney conduct that occurs in another jurisdiction, including before the federal court or federal agency. As I explained, this case arose from the cracks. It was not. Respondent was disciplined in federal court. There was an order, and she reported herself.
So under your theory, does your report of the federal court order in 2020, was that itself a grievance?
It was, even though at the time it was not required, but the respondent wanted to find out the steps. And at that time, the Chief Disciplinary Counsel, Ms. Sienna Willing, stated there is something in the making. So this case is very important to all of the attorneys in the future, reciprocal or not. Attorney is an attorney. Grievance is a grievance that alleges the facts of a grievance. The grievance means a writing statement for alleged attorney misconduct. Attorney misconduct includes, it doesn't say you attorney misconduct does not apply in reciprocal discipline. It does not state that.
Let me ask you this. The commission, to my reading of the materials, has not offered any alternative statute of limitation that would apply if the one in 1706 does not apply. So if the commission's decision is affirmed, would we be in a situation where there is no statute of limitation and the commission could have brought, if it wanted to, this action in another 5 or 10 or 20 years?
Correct. It would bring stale cases, claims, and it would unfairly prejudice an attorney. If they can go back decades, there wouldn't be a finality. That's why we have the statute. That's why we have the rules. And in this case, as I stated, it's a very important case because it's in the cracks, from the federal order of suspension to the state order of suspension. And as stated, respondents' actions, as I wanted to bring, I read when the commission stated that specifically, the commission further asserted that the respondent waived the limitation defense by not affirmatively pleading it in another way. But with regards to the limitation, if the limitation was not at issue, or if that would not have a finality for any Texas attorney, the respondent did, in her response and objection, pleaded the ex post facto law, which is constitutional, and it has the same, it functions in the same way, limiting stale and when it was not a punishment in the federal suspension in 2018, but it is now punishment. She did explicitly state ex post facto law, and together, if you combine them, it gives the limitation again that 1706 has the limitation, and it has specific exceptions, but it could have, next to compulsory discipline, added reciprocal discipline.
Well, let me ask you this. You mentioned that Rule 1706 is jurisdictional, I think you said.
Yes.
But but do we have to look at Rule 17.05, which also it seems to bear on this, because it says all the time periods in this rule are directory only, with certain listed exceptions. And one of the listed exceptions is not 1706. So by the terms of 1705, is this 4-year time period directory only?
Well, if you can paraphrase it, so.
Sure, I
because-
just noticed this in reading the rules, but Rule 1705, so a directory time period would not be jurisdictional. And so I'm just wondering what we do with that. If it's not an issue that was raised, and I understand the argument about, maybe this is a statute of limitations, or maybe it's not, and maybe it has to be raised, or maybe it's not. But if the time period is merely directory, it seems like it would be subject to waiver.
But we do have another case interpretation, and that is consistent with the definition of the 1706. I cited Delholme, we commissioned for lawyers' discipline, where the court held that the limitations period in disciplinary cases act as jurisdictional restriction, not merely a procedural requirement. And when the commission argued that 1706 does not apply to reciprocal discipline, which I stated is legally flawed, because the rule 9.04 of Texas Rules of Disciplinary Procedure governs the affirmative defenses in reciprocal cases, and it does not require limitation to be pleaded. So the commission improperly extended the reasoning from Baird, we commissioned for lawyers' discipline, which involved a direct disciplinary action, not a reciprocal. So reliance on Baird relied on Rule 94 of Texas Rules of Civil Procedure does not apply here, because the rules are distinct. The reciprocal rules based on 9.04, and respondent did assert A, B, C, but she did add the constitutional safeguard in there, the ex post facto. There is no limitation in there. And if you agree with the dissent with former Justice Emeritus Jason Boatwright, if you read his dissent, he has laid it out in a clear way. Direct discipline that follows the jury trial or whatever they have to follow the civil procedure. Reciprocal is discipline. It's confined to 9.04. And then the Rule 1706, again, explicitly states that compulsory discipline, something that involves fraud and concealment. That's why respondent reported herself several times to avoid the question about fraud or concealment. And as stated, with the entire opinion, the dissenting opinion from Justice Emeritus Jason Boatwright goes to the heart of it. This is the first case before the Supreme Court, and it is very important and fundamental that we have the interpretation that, as we state, that limitation period is jurisdictional. And the distinction, the intent of the statute is clear in Delholme v. Commission for Lawyers. There is no other way to read it as Justice Emeritus Jason Boatwright stated it. The language, as I cited in many from the Supreme Court, this court that states, even in Ray Clark, the cases that generally the express mention of enumeration of one thing, consequence, or class is equal to the express exclusion of all others. We have the rule, we have the limitation. Reciprocal discipline is not there. And the intent is clear from the previous cases. And the commission citing Baird or Bruno's case was never cited. Graham was never brought here for an opinion. This case is so fundamentally important that the attorneys need to have a safeguard against stale claims. It cannot go on years and years and decades and you come back, because this is not a criminal action, because if it was criminal action, compulsory discipline would have taken place, and that would have been the end of it. And if it was prosecutorial misconduct, the poor victim is 20 years behind bars. I understand. But if you look at the respondents in this case, what did she do wrong that we believe it's not proportionate, this punishment going on for almost 10 years?
Thanks, that answers my question.
Ms. Lane, your time has expired. Are there any other questions? Thank you for your argument.
Thank you.
We'll hear you in rebuttal. We'll hear from the commission.
May it please the court, Mr. Graham will present argument for the appellee.
Thank you, Mr. Chief Justice, Justices, and may it please the court. Texas Rule of Disciplinary Procedure 15.01 tells us that the purpose of lawyer discipline proceedings is to protect the public and the administration of justice from lawyers who have not discharged, will not discharge, or are unlikely to properly discharge their professional duties to clients, the public, the legal system, and the legal profession. As explained in our briefing, at least one court in another jurisdiction has referred to the purpose of reciprocal discipline as to deter other attorneys from engaging in similar misconduct and to notify members of the public of and protect them from attorney misconduct.
If the purpose of the system is, as you say, to protect the public and make sure justice is done with respect to lawyers, then why would we limit BODA's ability to notice that there's a legal deficiency in the case and raise that issue on its own, whether or not the lawyer has raised the issue?
Are you getting to the question of whether it's a waivable affirmative defense if limitations applies?
Yeah, if it's just sort of a big administrative apparatus designed to protect the public and do justice, as you said, then shouldn't BODA, if it notices that there's a problem with the case, act upon that, whether or not the lawyer has raised it?
I'm not sure that the rules do limit them from doing that. With respect to the question of whether it's a waivable affirmative defense, whether limitations is a waivable affirmative defense, courts of appeals that have addressed this issue, as we've mentioned in our briefing, described it as such, the limitations provision. That's why BODA approached it that way and has approached it that way in other reciprocal discipline cases. I'm not personally sure that that's what the statute of limitations in 17.06 is meant to be. It strikes me that it's more akin to a statute of repose in that it's meant to create a limitation from liability to that sort of thing.
Is it
Well,
if,
On that score, there are very few types of conduct in Texas that are subject to no statute of limitation,
That's correct.
right? Human trafficking, murder, those kinds of things. It seems the commission is trying to sort of put this in the same bucket and say you have forever to bring reciprocal discipline.
Well, no, let me back up. And that takes me to the question that you asked Ms. Lane, which I thought was a good question. The notion that, are we then in a boat where the commission can bring reciprocal discipline cases in perpetuity? The commission doesn't get the opportunity. The commission has the obligation under the rules to bring reciprocal discipline cases when it receives notice that a Texas attorney has been disciplined in another jurisdiction. It's not up to the commission to decide to bring the case. The rules tell us, bring the case. So then BODA gets to decide, once we put that case on, what's going to happen. There's no express limitation in that sense. I agree with you, Justice Huddle. However, if an attorney in that situation is defending their case, I think Part 9 does provide them some avenues to address those sorts of issues. The specific defenses include 904C, grave injustice, and 904D, substantially different discipline being warranted. if a respondent attorney in a circumstance like that could demonstrate to BOTA that the facts demonstrate, hey, the underlying conduct happened 20 years ago. Yeah, Illinois didn't sanction me until 2020, and the commission timely brought the suit when it received notice of that case. But you all need to take into consideration the fact that the actual conduct occurred 20 years ago.
Well, those defenses in C and D that you referred to essentially allow relitigation of the merits of the situation. And the question would be why? If it is stale, then there's a problem with that. And how do we know whether it's stale? Well, we've got a 4-year rule over here. Why don't we just apply the same rule in the reciprocal discipline situation?
Well, let me go over to why the commission, and I think BOTA, view the 17.06 limitations as not applicable to reciprocal discipline. I think Justice Busby hit on.
My question, though, is if you're sort of acknowledging, as I think everybody would, that there's some point at which these things become stale, and it would be perhaps a grave injustice to go after somebody, 10 years after the fact for something that memories have faded and all of that. And so if we're going to apply that kind of thinking to the reciprocal discipline regime, how do we identify the point in time at which it becomes unjust to go after the person? That's not stated in the reciprocal discipline rule. Why wouldn't we look elsewhere in the rules for the point in time at which the rules indicate these things become stale, which is 4 years?
Well, I mean, I think because the rules, our view of it, the commission's view of it, and BOTA's view of it, is that the rules don't indicate that a reciprocal discipline matter becomes stale because it's not initiated by a grievance as defined under the rules, and
Okay,
it's
so
not alleging.
So you would say 10 or 20 years later, it's fine if you realize, oh, this slipped through the cracks. There was discipline in Illinois 20 years ago, and we didn't notice it, and now we're required to bring that now. And
That's a different situation. That's a little bit different situation. If the discipline occurred 20 years ago, the actual foreign discipline occurred 20 years ago, and we only learn of it 20 years later, then I think certainly that's a consideration for, wow, I mean, this is way too long
There's
after.
nothing in the reciprocal discipline rule that says that.
And unless you view the defense of grave injustice as speaking to that, and grave injustice is not an easy thing to define. It's certainly not defined in the rules. I think it's in some ways subjective on the tribunal to determine whether a grave injustice has occurred, and it's up to the respondent attorney to demonstrate that by clear and convincing evidence, or they could go to the other section, subsection D, which talks about maybe in this case substantially different discipline is warranted than what was imposed there. At the end of the day, if a respondent attorney proves one or more of those defenses, that doesn't necessarily mean they're not going to get disciplined. What the rules say is, at that point, BOTA can issue orders that it deems appropriate and necessary. That might mean they simply deny the reciprocal discipline altogether. It might mean that they issue a different discipline that's not identical to the extent practicable to the discipline that is supposed to be imposed if they can't prove one of those defenses. Maybe they impose less, let's say somebody got suspended for a year in the other jurisdiction. Maybe BOTA determines then, well, because of the passage of time, we're only going to suspend you for 3 months, or we're going to say that we're imposing the same discipline, but recognizing that time has passed and essentially your suspension has been served. I think it would be okay for them to issue an order like that in that circumstance.
So what is your response to the idea that it's particularly onerous that this reciprocal discipline would not be served concurrently with other discipline? In other words, your livelihood is serially impaired throughout a career, as opposed to happening at or near the time the initial discipline is imposed. That seems to be problematic.
Well, I think in certain circumstances it certainly can seem onerous and can seem problematic. I don't think the rules expressly tell BOTA how to deal with that situation, if that's what they feel like they're confronted with. I mean, I'll give another example of a similar case that went before BOTA, and in fact was appealed to this court recently. Let me give you the reference number. It dealt with an attorney named Cressy, and it's this court's case number 23-0352. In that case, the underlying conduct that got Mr. Cressy in trouble in another jurisdiction occurred in November 2016 and up to potentially March of 2017. Foreign discipline issued from New Jersey in 2019. He was disbarred in 2019. Well, that was in March of 2019. In September of 2019, New York disbarred him. In October of 2019, Pennsylvania disbarred him. The commission didn't learn of any of those disbarments until 2021. So in March of 2021, the commission initiated reciprocal discipline proceedings. Eventually, BOTA issued a reciprocal discipline judgment in May of 2023, disbarring that attorney in Texas. The conduct that he was disbarred for in Texas occurred in 2016 and maybe 2017. Reciprocal discipline didn't issue until 2023. The commission didn't even know about it until 2021. No one in BOTA dissented to that. Now, Mr. Cressy didn't raise a statute of limitations argument. That might get you to the question of
Wait,
whether
what was the date of the New Jersey disbarment?
The New Jersey disbarment was in March of 2019.
Okay, so in this case, it looks like the federal court issued the 6-month suspension in 2018.
Yes.
So even if it's the underlying action plus a final decision, determination about discipline, that triggers some sort of limitations period, triggers the 4 years, this would be outside the 4 years if you count the federal discipline.
Well, but understand, at the time the federal, first of all, and I don't remember which justice hit on this, but it might have been Justice Busby. It's not the federal discipline that's at issue here, it's Illinois state discipline. Now,
It was not reciprocal, right?
It was not reciprocal.
Illinois state discipline was fully contested and treated
Right.
as an ordinary disciplinary
And let me
proceeding based on
explain
the
that.
same underlying conduct.
yeah, let me explain that. So what happened is, Ms. Lane was involved in some federal litigation in the Northern District of Illinois. And she sent these emails that called into question arguably the integrity of the trial judge. And that trial judge eventually filed a federal disciplinary complaint against her, and the federal court dealt with it as federal courts do before a committee and issued its discipline in 2018. Illinois initiated its own standard discipline case based on the same conduct, and that proceeded through their standard discipline process and led to our discipline case.
Which didn't terminate until the Illinois Supreme Court issued its ruling.
That's right. That's
Now,
right.
is there anything in the rules that directs BOTA which, if you have two merits disciplines based on the same conduct, is there anything that directs BOTA which of those to consider in terms of applying the 4-year period?
Well, no, not really. And of course,
But
BOTA's
there is, but the reason Cressy is not really helpful here is that there is a specific exception for the situation you're talking about in 1706D, which is a tolling provision that tolls your 4-year period in cases of fraud or concealment, which is, I hope you would concede what there was in the Cressy case if he did not self-report for years after he'd been disbarred. That's not our situation. Right?
I'm not sure that's how that's meant to apply, and it certainly is not how it applied in Mr. Cressy's case. I mean, I'm just not sure.
Well, but you do agree with me, though, that 1706D is a tolling provision for when there's fraud or concealment.
Certainly.
And in that situation, what it tells us is that you don't begin to count the 4-year period until, was discovered or should have been, until the professional misconduct should have been discovered or was discovered.
Right.
So that's an exception to the general rule. And the general rule is that the limitations period or the 4-year period begins when the professional misconduct occurs.
Yes, but in the context of reciprocal discipline,
Well, does it though? I mean, this gets back to the question of how professional misconduct
that's
is
exactly where I was
defined.
going,
Okay.
Justice Busby. In the context of reciprocal discipline, professional misconduct in Texas adheres when an attorney engaged in conduct outside of Texas and was disciplined for it in that other jurisdiction. You have to have the resultant discipline in order for it to constitute Texas professional misconduct for the purposes of reciprocal discipline.
Which gets back to my question, because you had that at the time the federal court issued their decision.
No, we didn't, because at the time of the federal court decision, and at the time Ms. Lane first sent her email to the CDC saying, I got disciplined by the federal court in 2018, the rules did not expressly include
Federal discipline.
federal discipline, neither in 803 F of the TDRPCs regarding self-reporting, nor in Part 9 of the TRDPs regarding reciprocal discipline. Those rules didn't change until the amendments that were effective as of July of 2021, and they changed both 803F and Part 9 to expressly include discipline from federal courts or federal agencies. Nothing in those rules, and certainly nothing in Part 9, indicates that that was meant to be retroactive to federal court discipline that had been issued in 2018. So assume, and this gets to the CDC's response to Ms. Lane when she emailed in 2020, which was to say, if you're telling me that you've been disciplined in federal court, and I see that you're telling me that Illinois is running a proceeding about that, I'm telling you that you don't have a duty to report that because there's no such express duty. And though the CDC didn't expressly say this in response, the other response would be, and we don't have grounds to discipline you in a standard context, or in a reciprocal context, because the reciprocal rule right now doesn't say anything about federal court or federal agency discipline.
Do they have grounds to discipline her in a standard context?
They would not have, because when okay, let me explain this a different way too. So you've got an attorney who's working in Illinois and is licensed in Illinois and happens to also be licensed in Texas. That attorney does conduct that's indisputably happening in Illinois. It is certainly within Illinois' purview, federal court or state court, to discipline that attorney. As far as her Texas licensure goes, what the rules tell us, and this goes back to the jurisdictional rule that's contained in TDRPC 8.05A, what that rule tells us is that attorneys in Texas are subject potentially to the disciplinary authority of the state for their conduct that occurs outside of Texas, but only when it's a violation of Rule 8.04. And in this context, there isn't a clear analogy between any rule in our Texas 804 and the things that Ms. Lane was disciplined for in the federal court case. Does that answer your question, Justice Young?
So the only basis then for Texas disciplining her at all as a Texas lawyer is that some other jurisdiction.
Well, no.
At the time, that some other state jurisdiction.
Yes.
Some other state, yes, but it's another different jurisdiction, not Texas.
Yes, for that conduct at that time, the only way that we could move forward is if she was disciplined, and it would be under the reciprocal discipline rules.
Let me ask you about how 17.05 bears on how we should read 17.06. And it seems like it's saying that this time period is directory.
I thought that was a really interesting question you asked, Justice Busby, and I hadn't thought about that before. That certainly is what 17.05 says.
So what do you do with that?
Well, I'm not sure what you would do with it, because normally the time frames that you're talking about when you're referring to what it accepts in 17.05 are, for instance, in standard discipline proceedings that go before a district court, there's a rule that says the trial's got to be held within 180 days of it being filed. Sometimes we blow past that. And, you know, the parties can agree to blow past it and things like that. But let's say the parties didn't agree to blow past it, And the respondent attorney brings that up at trial and says, we're at 300 days. We can't go forward anymore because the rule says it had to happen within 180 days. There are a number of cases out there that say, yes, but look at Rule 1705, which specifically tells us that that's
Consequences, not
directory
dismissal.
only.
Right.
It's not mandatory, it's not jurisdictional, so it doesn't apply to invalidate anything that's happened, and that's what Rule 17.05 tells you.
The idea is that it's not really a statute of limitations, but the rule of limitations in 1706 is not a time period to which 1705 refers.
I think that's right.
Yeah.
Conclusion of law number 5 from the board suggests that at least somebody thinks that when this court affirms a BOTA judgment, that there is some kind of a blessing or a concurrence from this court with the legal analysis or conclusions of law in the BOTA papers. Is that your understanding of what's going on when this court affirms the result at BOTA?
I wouldn't say that that's my express understanding. Let me explain that, Justice Blacklock, because this is a point that Justice Boatwright made in his dissent, and I understand where he's coming from, but I'm not sure that it means the same thing in the context of, say, reciprocal discipline or compulsory discipline that it would mean in a standard discipline case. And what I mean by that is this. The dissent says, well, we don't want to be binding trial courts and appellate courts to our decisions just on the basis of an unpublished, not a written opinion, affirmance by the court, because I don't know that means the court is blessing the merits of what we've decided. And maybe that's true. But reciprocal discipline cases and compulsory discipline cases are a little bit different because the only information we have to guide ourselves as to what the law is are the rules, what BOTA says, and what this court says. Those cases don't go before trial courts. They don't go before intermediate appellate courts. They only go to those two tribunals. So does the court affirming without written opinion in those cases necessarily mean that the court agrees with everything that BOTA said? I guess it doesn't necessarily mean that, but it doesn't mean...
It may mean nothing other than that we are declining to interfere with what BOTA has done.
It might mean that.
In the same way in which we deny a petition for review.
Well, and that was going to be my next point is, I'm not sure it should be treated exactly the same as a petition for review situation because, remember, petitions for review come through intermediate appellate courts. If an intermediate appellate court affirms a lower court, then it is saying we agree with what they did.
One last quick thing.
Sure.
Rather than sort of say, oh, there is no limitation on a temporal limitation on when this kind of action can be brought in reciprocal discipline context. What is your take on whether residual provision in the Civil Practice and Remedies Code 16051 says if there is no expressly applicable statute of limitation, we're going to apply 4 years?
I hadn't thought about that, Justice Settle. I think my initial response would be, well, I don't know that there's any authority that incorporates the Texas Civil Practice and Remedies Code into attorney disciplinary proceedings. There are different places in the rules or in BOTA's internal rules where, for instance, the rules of evidence are incorporated or the rules of civil procedure or the rules of appellate procedure are incorporated. But there isn't anything that incorporates the Civil Practice and Remedies Code, and that to me, that makes some sense because that's a legislative statute. And the people that are in charge of the attorney disciplinary system are this court. It's a judicial branch issue. So I'm not sure that Civil Practice and Remedies Code section would have any application. What I don't want to be perceived to be saying is that the commission or the CDC or even BOTA, I can't speak for BOTA, but I think they believe this, is that if a reciprocal discipline case comes before them that's so old that it shakes the conscience or whatever, that there's nothing they can do about it. I mean, I think that the rules allow for a respondent attorney to offer as a defense, amongst other things, this just isn't right. This is a grave injustice, or it warrants substantially different discipline. But they have to demonstrate that by clear and convincing evidence. And in this case, BOTA determined that Ms. Lane hadn't demonstrated any of those. In fact, she hadn't brought a defense under subsection D or E. She had brought one under subsection C for grave injustice, but the court BOTA didn't believe that she had met that burden. So,
Any other questions? Thank you, counsel.
thank you very much.
Ms. Lane, you have 5 minutes. Oh, 3 minutes, I'm sorry.
Thank you again. This case is not about one attorney disciplinary proceeding. It is about reaffirming the principles of fairness, proportionality, and jurisdictional integrity enshrined in Rule 1706 of Texas Rules of Disciplinary Procedure. Rule 1706 exists to protect attorneys from stale claims, unjust punishment. The court has an opportunity to affirm the principles and prevent commission from exceeding its authority. There are no definitions for attorney misconduct for local attorneys and a conduct from a different jurisdiction. The definitions do not make any different definition for attorney misconduct in the other jurisdiction versus in the Texas. So therefore, if we apply that rule, the reciprocal discipline is not an exception in 1706. The law is clear. 1706 contains only 2 specific exceptions. And concealment is not the situation here, as a respondent explained. From day one, she has brought this finality imposement of discipline on her to CDC's attention. So 2 exceptions are clear. It says compulsory discipline exception, and then if there is a fraud or concealment or prosecutorial misconduct. Expressio unius e exclusio alterius is clear. Expanding exception beyond what is explicitly stated in Rule 1706 would undermine its purpose and create procedural uncertainty for all Texas attorneys. However, even if we, assuming arguendo that limitation had to be pled, Respondent Lane's assertion of the ex post facto clause in show cause response serves the same purpose, because this highlights that the protection of Rule 1706 and constitutional principles like the ex post facto clause work together to ensure fairness, particularly in reciprocal discipline cases like this one. The respondent's conduct in the federal court in 2017 did not cause any harm to client, no financial loss, no disruption to justice. It did not involve misappropriation of funds, criminal acts, dishonesty, where there are exceptions in 1706 listed for prosecutorial misconduct, concealment, and otherwise. For the same reason, assuming arguendo, she did bring it, and this highlights the protection when they work together better. Disciplining an attorney years after the alleged misconduct, again, the misconduct, if you look it was representing a client in a heated case. It was not personal gain, crime, or anything. After so many years beyond the statutory limitation period is not only a clear overreach of authority, but also unlawful act that seriously violates the principle of fairness and proportionality. We do not want to create a BOTA rule because Texas Supreme Court affirmed the ruling from BOTA. It did not assent that the discipline 4-year limitation does not apply to reciprocal discipline. This court has the opportunity to reinforce this jurisdictional safeguard provided by Rule 1706 and ensure the disciplinary process remains transparent, equitable, and consistent for all attorneys. By adopting the dissent's reasoning and reversing the disciplinary action against Attorney Lane, this court can reaffirm its commitment to justice and the rule of law. I urge the court to adopt the dissent's reasoning, recognize the grave injustice that she cited in her show cause response 9.04, recognize the grave injustice in this case, and reverse the imposition of reciprocal discipline. Further, I would like to just add one, again, Texas Supreme Court discussion that was cited in Robinson v. Weaver from 1977. It says specifically, statute of limitations are not directed to the merits of any individual case. They are result of legislative assessment of the merits of cases in general. The fact that meritorious claims, different cases claims, might thereby be rendered non-assertable is an unfortunate. Occasionally byproducts by the operation of limitation. We have a clear rule, 1706, and it has protection for stale cases to prevent the commission from exceeding its authority. Justices, I appreciate your time and consideration for this very important case for all the Texas attorneys going forward. Thank you for your time and consideration.
Any questions? Thank you, Ms. Lane. Case is submitted, and the court will take another brief recess.
Rise.